The courts protect bully children in schools, don't they? The following presentation is at the address of the Young Queenslanders Against School Bullying Association. The issues as raised in this presentation will specifically focus on negligence liability surrounding bullying in schools and will speak to the growing epidemic of all types of bullying in both public and private schools. As such, this will speak to where current liability law is at regarding this issue, and further recommendations as to how to improve the law. Griffith Law Against School Bullying aims to highlight this area of law, particularly regarding the difficulty from victims of bullying to bring actions and seek remedies. Bullying is a widespread issue in schools and is largely accepted as a normality in Western societies. Butler. Australia is no exception, wherein current reports determine that 46% of children in Australia have experienced bullying-like behaviour just in the year of 2016. According to the Australian Institute of Health and Welfare. It is largely accepted that Australian schools have among the highest bullying rates in the world. Resulting from bullying, victims may experience direct physical injuries or psychological injuries taking the form of depression and anxiety, according to stopbullying.gov. And with the emergence of more dependence on technology, the term cyberbullying has been coined to match the rising reliance on technology to barrage users with repeated hostile behaviour. Adams. The long-lasting impact of large-scale bullying means future society will be burdened by incredibly insecure individuals, leading to withdrawn and stunted growth development of many young people, Riviere and Menestral. In some extreme cases, such as that of Alan Hawkey in 2009, these instances may result in suicide at the hands of prolonged harassment, Dwyer and Eastle. Ultimately, the issue of bullying is widespread, owing to an increasing litigiousness in Australian society. The reliance of common law damages in negligence may be used to seek restitution for instances of bullying in school. What was once a teacher's or school's ethical responsibility to address bullying and student welfare is now a legal responsibility. Butler. As such, this presentation will address the scope to which schools can be held liable for negligence in failure to prevent students from being bullied on school grounds. Persistent with the issues arising negligence, the elements of negligence will be discussed and analysed per case basis, and then subsequent recommendations will be suggested, that to which will seek the remedy this area of negligence liability. Despite Australia's growing issue of bullying, there are surprisingly few cases surrounding bullying and negligence actions. Stewart and Ford. More still, there has been very little legal analysis regarding cyberbullying. In the first instance regarding a duty of care, a school, regardless of its classification of state or private, owes its pupils a non-delegable duty of care, Diocese of Bathurst and Kaufman, whether by contract in the case of private schools or by the state in cases of public institution. The point has been affirmed in Leopold and New South Wales and is undisputed that this duty of care exists towards pupils in all cases of this nature. It is also largely considered that an obligation is put on the school to ensure that anti-bullying measures are effectively implemented to deal with bullying in schools, Kendall and Sidebottom. In instances of public schools, Intravigny and the Commonwealth affirms that the Crown is liable in tort for teachers' acts or omissions in the court of his employment. However, the issue as described in the beginning of the presentation arises with the scope of this duty of care. In essence, the question must be big: how long is a piece of string? There is clear uncertainty in Queensland, indeed the whole country, as to how far this scope extends. However, cases do seemingly provide a wide scope upon which this duty does extend, with Gaillard and Downs demonstrating that duty of care to students extends time-wise beyond the allotted hours of supervision. So long as there is pupil-teacher relationship, there are kids on the school ground who are owed a duty of care. The findings in Commonwealth and Intervene also provide that supervision and thus duty of care extends before allotted school hours, owing to occurrence of students on school grounds. A pupil-teacher relationship exists. In terms of physical bounds to the scope, the trustees of Roman Catholic Church for the Diocese of Bathurst and Kaufman consider the scope of the duty to extend at least 400 metres from the gates of the school. In this case, a boy was hurt by other pupils at a bus stop 400 metres down the road. These current cases would seem to indicate that the scope of a teacher's duty of care extends literally outside of school hours and grounds to a certain extent. In most respects, the duty of care is clear in as far as its extended geographical and time restraints. However, exact limits have not been drawn in every case. However, in application to cyberbullying, an example of a student using home social media not related to the school will still likely not fall within the scope of duty of the school. Campbell. Breach. Section 9, subsection 1A of the Civil Liability Act 2003 provides that a breach may occur when the risk was foreseeable to which the person reasonably ought to have known. A two-tier test is provided in section 9.1a, providing a factual causation in subsection 1a, and the scope of liability is covered in subsection 1b. The current application of these tests determines that schools cannot be breached simply where bullying is reasonable foreseeable in the circumstances. Butler. In the case of Australian Capital Territories Schools Authority, and L. Sheik exemplifies this, wherein a schoolboy with a congenital condition was kicked during a play fight resulting in serious harm. The courts made it clear that the school has a duty to take reasonable steps, particularly supervision, to protect students from a significant violent behaviour and prolonged physical attention. The risk in this case, a play fight, represented mere horseplay, considered normal to teenagers. It would not be reasonable to employ an army of supervisors to prevent kids participating in violence. The case, however, indicates that the duty does not extend to protecting an apparently normal 15-year-old from receiving, over a short period of time, play fight kicks from his friend, even painful play fight kicks. The risk in this instance of injury was not foreseeable, and adequate mitigation of the risk was not reasonable upon the reasons listed above. Plainly, the courts have a particularly lenient view on violence, and that, in most respects, violence is to be tolerated by teachers in the most reasonable fashion. This creates issues per bullying in schools, where it might be hard to determine where the line is drawn into terms of violent behaviour and mere horseplay. The case of Gregory, New South Wales highlights a stricter approach taken by courts, upon which a student suffered prolonged bullying via verbal and physical contact, which was not stopped by teachers despite knowledge of the bullying. The student's experiences in high school led to lifelong and immediate psychological injuries leading to economic loss. Little is said regarding the breaching duty. However, it is mentioned numerously that teachers, even at some point supervising at the time of the bullying, did nothing to stop the events from occurring. Considering damages were awarded, it can be gleaned that it was foreseeable that the risks associated with continuous bullying were foreseeable to teachers pursuant to Section 9, subsection 1a, and there was effectively no negative calculus pursuant to Section 9, subsection 2, associated with stopping the risk from occurring. In most respects, it is hard to determine where the point at which aggressive behaviour directed at the plaintiff child goes beyond what may be regarded as healthy and formative instead becomes damaging. In applying this to cyberbullying, it was seen that schools in Queensland now have the power to discipline students if they were found using technology appropriately outside of or inside of school hours, providing the possibility of a breach for not enforcing the standard. Dwyer and Eastle. Causation. Causation is governed by Section 11 of the Civil Liability Act, which Section 11, subsection 1a, the breach was a necessary condition of the occurrence of the harm or factual causation, and subsection 1b, it is appropriate for the scope of the liability of the person in breach to extend to the harm so caused. As such, there is a two-tier test resulting in factual causation and the scope of the liability. Comparatively, the causal connection between breach duty and harm, particularly psychological harm stemming from bullying, is largely a non-issue to prove in Australian courts. Per Wallace and Cam, Section 11.1a is a simple but-for test application. Consequently, the plaintiff is required to show the injury would not have arisen but for the breach of the duty by the school authorities. In Oyston and St. Patrick's College, a case involving a student developing psychological issues from bullying, The courts plainly concluded at 320 that the college's failure to bring the misbehavior of other students to an end was the major contributing factor in my assessment of the evidence, the significant cause of the injury. In addressing the scope of liability, the courts ruled at 331 that even if injury was disproportionate than what might have been expected from bullying, the scope of the college's liability extended to the harm which was caused. The court considered the school's continual avoidance of the issue that was faced by the plaintiff and did very little in a way to prevent it. This case demonstrates an example that the courts are more than willing to rule there is a causal link between bullying and psychological harm suffered when there is both factual causation in the breach of the teacher's delegable duty as well as an appropriate scope in considering the flow-on effects of bullying throughout a person's life, particularly where the school authorities did nothing to prevent the bullying, despite knowledge of its existence and effects. Referring to cyberbullying, again where the law has no considered approaches to cyberbullying, it is considered by academics that if the plaintiff is able to show that the school's failure to prevent cyberbullying in breach of its duty of care was one of the material causes of the resulting psychological harm, as opposed to, for example, the sole dominant cause, then likely causation will exist. Butler. The defense most likely to be utilized in a scenario of negligence and bullying is contributory negligence, governed by Section 10 of the Law Reform Act 1995. Where the plaintiff has risked themselves to a risk of injury that might be reasonably foreseen and avoided, and the plaintiff suffers an injury within that class of risk to which the plaintiff was exposed, there may be contributory negligence, per Joslin and Berryman. In Copping and State of South Australia and Lightbody, a case of a 9-year-old being struck in the eye by a rock after engaging in a rock throwing contest with much older children, the plaintiff was found guilty of contributory negligence. The courts used the Commissioner of Railway and Ruprecht in applying the standard to the foreseeability of being that of a reasonable and prudent man. As such, the courts considered that a 9-year-old should have foreseen that throwing rocks was likely to result in the response which occurred, and that a reasonable 9-year-old would have vacated the vicinity to avoid having rocks thrown at them. Here the courts take a very strict approach in what the foreseeability expected of a school student, particularly a 9-year-old, should be. Alternatively, in the state of New South Wales and Griffin, involving a 13-year-old girl suffering a brain injury from a schoolyard fight, the courts argued at paragraph 10, that the respondent's conduct was part of the foreseeable folly of youthful exuberance, and the conduct was to be stopped by the appellant, the school. As such, the defense of contributory negligence was not successful. This approach by the court seems to be counterintuitive, where it would be argued by a reasonable person that a 13-year-old reasonable person would much likely possess greater powers of foreseeability than a 9-year-old. However, it is also clear that courts pay attention to the context upon which these students live, and in doing so, it limits the potential for contributory negligence. However, in most cases of bullying, this defense is not useful, whereas likely the school has been informed of the bullying, hence causing negligence in the failure to perform their duties, like seen in Oyston and St. Patrick's College. Voluntary assumption of risk may also be used, however, in the context of plaintiffs which are children, it is most likely not to be successful. Hanley and Burke. It remains to be seen whether the law can be improved for those seeking justice. With cases such as Oyston and St. Patrick's College, it can be gleaned that the law is approaching bullying with a more effectual and understanding response, particularly in relation to psychiatric injuries. However, it still remains questionable as to whether the court considers bullying or simply horseplay. In reference to cyberbullying, clearly still a new issue, Research has suggested that civil enforcement regime, CER, to be introduced. The advantages of such a regime will allow for a simpler, clear structure for schools to respond to incidents of cyberbullying more effectively, with less emphasis on tort law. Instead, focus more on a mediation process and education programs to prevent cyberbullying in schools, per Katz et al.